Hey guys, welcome to my channel. My name is Hiten. I am an advocate practicing in Jalandhar. In today's video, let's talk about the relevant sections of Motor Vehicles Act 1988 relating to compensation in motor accident claims. The Motor Vehicles Act 1988 is a beneficent legislation intended to place the claimant in the same position that he was before the accident and to compensate him for his loss. Chapter 10 of Motor Vehicles Act 1988 deals with liability without fault in certain cases. Section 140 Liability to pay compensation in certain cases on the principle of no fault. Subsection 1 says where death or permanent disablement of any person has resulted from an accident arising out of the use of a motor vehicle or motor vehicles, the owner of the vehicle shall, or as the case may be, the owners of the vehicles shall, jointly and severally be liable to pay compensation in respect of such death or disablement in accordance with the provisions of this section. Subsection 2 says the amount of compensation which shall be payable under subsection 1 in respect of the death of any person shall be a fixed sum of 50,000 rupees, and the amount of compensation payable under that subsection in respect of the permanent disablement of any person shall be a fixed sum of 25,000 rupees. Some judgments related to this section are Ishwarappa versus Guru Shanthapa. In short, it says, to attract the liability under section 140, all that is required is an accident arising out of the use of a motor vehicle leading to death or a permanent disability of any person. Tithi versus Motor Accidents Claims Tribunal. In short, it says, under section 140 of the Act, the liability of owner or owners of the vehicle or vehicles is joint and several. This section contemplates involvement of two or more motor vehicles. In an accident involving two motor vehicles, liability to pay compensation is upon both the owners of the vehicles. In such cases, when an owner of one vehicle is identified, he is liable to pay compensation because the liability is joint and several. The claim under section 140 cannot be defeated in such cases on the ground that owner of other vehicle is not detected. Section 141 Provisions as to other right to claim compensation for death or permanent disablement. Subsection 1 says the right to claim compensation under section 140 in respect of death or permanent disablement of any person shall be in addition to any other right except the right to claim under the scheme referred to in section 163A. Such other right hereafter in this section referred to as the right on the principle of fault to claim compensation in respect thereof under any other provision of the Act or any other law for the time being in force. Chapter 11 of Motor Vehicles Act 1988 deals with insurance of motor vehicles against third-party risks. Section 146 Necessity for insurance against third-party risk. Subsection 1 says, no person shall use except as a passenger or cause or allow any other person to use a motor vehicle in a public place unless there is in force in relation to the use of the vehicle by that person or that other person, as the case may be, a policy of insurance complying with the requirements of this chapter, provided that in the case of a vehicle carrying or meant to carry dangerous or hazardous goods, there shall also be a policy of insurance under the Public Liability Insurance Act 1991. Here we have a judgment. National Insurance Company Limited versus Geeta Bhatt. In short, it says the owner of the vehicle is statutorily obligated to obtain an insurance for the vehicle to cover the third party risk. Section 149. Duty of insurers to satisfy judgments and awards against persons insured in respect of third party risks. Subsection 1 says, if after a certificate of insurance has been issued under subsection 3 of section 147 in favor of the person by whom a policy has been effected, judgment or award in respect of any such liability as is required to be covered by a policy under clause B of subsection 1 of section 147, being a liability covered by the terms of the policy or under the provisions of section 163A, is obtained against any person insured by the policy, then notwithstanding that the insurer may be entitled to avoid or cancel or may have avoided or cancelled the policy, the insurer shall, subject to the provisions of this section, pay to the person entitled to the benefit of the decree any sum not exceeding the sum assured payable thereunder, as if he were the judgment debtor, in respect of the liability, together with any amount payable in respect of costs and any sum payable in respect of interest on that sum by virtue of any enactment relating to interest on judgments. Section 161. Special provisions as to compensation in case of hit and run motor accident. Subsection 1 says, for the purposes of this section, section 162 and section 163, grievous hurt shall have the same meaning as in the Indian Penal Code. Hit and run motor accident means an accident arising out of the use of a motor vehicle or motor vehicles, the identity whereof cannot be ascertained in spite of reasonable efforts for the purpose. Scheme means the scheme framed under section 163. Subsection 2 says, notwithstanding anything contained in the General Insurance Business Nationalization Act 1972 or any other law for the time being in force or any instrument having the force of law, the General Insurance Corporation of India formed under section 9 of the said act and the insurance companies for the time being carrying on general insurance business in India shall provide for paying in accordance with the provisions of this act and the scheme compensation in respect of the death of or grievous hurt to persons resulting from hit and run motor accidents. Subsection 3 says, subject to the provisions of this act and the scheme, there shall be paid as compensation in respect of the death of any person resulting from a hit and run motor accident a fixed sum of 25,000 rupees, in respect of grievous hurt of any person resulting from a hit and run motor accident a fixed sum of 12,500 rupees. Here we have a judgment. Tithi versus Motor Accident Claims Tribunal. In short, it says, in a claim under section 161 of the Act, there must be proof that the identity of the vehicle or vehicles cannot be ascertained in spite of the reasonable efforts in that behalf. When identity of the vehicle is ascertained, it may not be a case of hit and run motor accident. Section 163. Scheme for payment of compensation in case of hit and run motor accidents. Subsection 1 says the central government may, by notification in the official gazette, make a scheme specifying the manner in which the scheme shall be administered by the General Insurance Corporation, the form, the manner and the time within which applications for compensation may be made, the officers or authorities to whom such applications may be made, the procedure to be followed by such officers or authorities for considering and passing orders on such applications, and all other matters connected with or incidental to the administration of the scheme and the payment of compensation. Section 163A. Special provisions as to payment of compensation on structured formula basis. Subsection 1 says, notwithstanding anything contained in this act or in any other law for the time being in force or instrument having the force of law, the owner of the motor vehicle of the authorized insurer shall be liable to pay in the case of death or permanent disablement due to accident arising out of the use of a motor vehicle, compensation as indicated in the second schedule to the legal heirs or the victim as the case may be. Subsection 2 says, in any claim for compensation under subsection 1, the claimant shall not be required to plead or establish that the death or permanent disablement in respect of which the claim has been made was due to any wrongful act or neglect or default of the owner of the vehicle or vehicles concerned or any other person. Here we have a judgment. Oriental Insurance Company Limited versus Thun by Kanji Gandhi. In short, it says remedy for payment of compensation both under section 163A and section 166 being final and independent of each other as statutorily provided, a claimant cannot pursue his remedies thereunder simultaneously. The claimant must elect to go either for proceeding for 163A or under section 166 of the Act, but not under both. Section 163B. Option to file claim in certain cases where a person is entitled to claim compensation under section 140 and section 163A. He shall file the claim under either of the said sections and not under both. Chapter 12 of the Motor Vehicles Act 1988 deals with claims tribunals. Section 165, Claims Tribunal. Subsection 1 says, a state government may, by notification in the official gazette, constitute one or more motor accidents claims tribunals for such area as may be specified in the notification, for the purpose of adjudicating upon claims for compensation in respect of accidents involving the death of or bodily injury to persons arising out of the use of motor vehicles or damages to any property of a third party so arising or both. Section 166, Application for compensation. Subsection 1 says, an application for compensation arising out of an accident of the nature specified in subsection 1 of section 165 may be made by the person who has sustained the injury or by the owner of the property, or where death has resulted from the accident by all or any of the legal representatives of the deceased, or by any agent duly authorized by the person injured, or all or any of the legal representatives of the deceased, as the case may be, provided that where all the legal representatives of the deceased have not joined in any such application for compensation, the application shall be made on behalf of or for the benefit of all the legal representatives of the deceased, and the legal representatives who have not so joined shall be pleaded as respondents to the application. Some judgments related to this section are Amrit Bhanu Shali versus National Insurance Company Limited. In short, it says selection of multiplier is based on the age of the deceased and not on the basis of the age of the dependents. There may be number of dependents of the deceased whose age may be different, and therefore the age of the dependents has no nexus with the computation of compensation. Urvi Ben Chirag Bhai Seth versus Vijay Bhai Shambhu Bhai Joran Putra. In short, it says compensation may be so assessed that the interest accruing therefrom will be sufficient for the maintenance of the family of the victim, and the concept of compensation is wider than mere damages. Uttar Pradesh State Roadways Transport Corporation versus Shanti Devi. In short, it says, in case of application for compensation, it is not necessary for the claimant to plead evidence in the petition. It is suffice for claimant to convey to the respondents that it was due to their act that the victim met with an accident which killed him. Thus, when the rashness causing accident is made the basis for claiming compensation, the non-disclosure of the manner of the accident does not make the petition incomplete, nor leads to the conclusion that the cause of the action had not been disclosed in the petition. Section 167. Option regarding claims for compensation in certain cases, notwithstanding anything contained in the Workmen's Compensation Act 1923, where the death of or bodily injury to any person gives rise to a claim for compensation under this act, and also under the Workmen's Compensation Act 1923, the person entitled to compensation may, without prejudice to the provisions of Chapter 10, claim such compensation under either of those acts, but not under both. Here we have a judgment. Sheikh Iman Bai versus Oriental Fire and General Insurance Company Limited. In short, it says, once option was exercised and an award was passed under Workmen's Compensation Act 1923, it is not open to claimants to avail the remedy under the Motor Vehicles Act. Section 168. Award of the Claims Tribunal. Subsection 1 says, on receipt of an application for compensation made under Section 166, the Claims Tribunal shall, after giving notice of the application to the insurer and after giving the parties, including the insurer, an opportunity of being heard, hold an inquiry into the claim, or as the case may be, each of the claims, and subject to the provisions of Section 162, may make an award determining the amount of compensation which appears to it to be just, and specifying the person or persons to whom compensation shall be paid, and in making the award, the claims tribunal shall specify the amount which shall be paid by the insurer or owner or driver of the vehicle involved in the accident, or by all or any of them as the case may be, provided that where such application makes a claim for compensation under Section 140 in respect of the death or permanent disablement of any person. Such claim and any other claim, whether made in such application or otherwise, for compensation in respect of such death or permanent disablement shall be disposed of in accordance with the provisions of Chapter 10. Subsection 2 says the claims tribunal shall arrange to deliver copies of the award to the parties concerned expeditiously and in any case within a period of 15 days from the date of the award. Subsection 3 says when an award is made under this section, the person who is required to pay any amount in terms of such award shall, within 30 days of the date of announcing the award by the claims tribunal, deposit the entire amount awarded in such manner as the claims tribunal may direct. Some judgments related to this section are K. Suresh versus New India Assurance Company Limited. In short, it says just compensation. Despite many pronouncements in the field, it still remains a challenging situation warranting sensitive as well as dispassionate exercise how to determine the incalculable sum in calculable terms of money in cases of personal injuries. In such assessment, neither sentiments nor emotions have any role. There should be grant of just compensation. Thus, it becomes a challenge for a court of law to determine just compensation, which is neither a bonanza nor a windfall and simultaneously should not be a pittance. However, it would involve some guesswork as there cannot be any mathematical exactitude or a precise formula to determine the quantum of compensation. In determination of compensation, the fundamental criterion of just compensation should be inhered. Panna Singh versus Himangshi Karmakar. In short, it says, it is well settled that tribunal or court is to determine the fair amount of compensation awardable to the victim of any accident or to the dependent of the deceased, which must be proportionate to the injuries caused to him or for the cause of his death, and the tribunal or court cannot go by the ready reckoner. Oriental Fire and General Insurance Company Limited versus Masi Ram. In short, it says just compensation, even if the same is more than the amount claimed, can be awarded. And finally, we have section 171, award of interest, where any claim is allowed. Where any claims tribunal allows a claim for compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date, not earlier than the date of making the claim, as it may specify in this behalf. So that covers some of the relevant sections of the Motor Vehicles Act 1988 relating to compensation in motor accident claims. And that's it for today. If you like this video, give it a thumbs up, share it with your friends and family. Don't forget to subscribe to the channel, and if you have any questions, please do leave them in the comment section below. Thanks for watching, and I'll catch you in the next video.